Welcome to Faith and Freedom. For the next few minutes, we hope to inform, inspire, and encourage you as we discuss legal victories and challenges to your fundamental freedom and religious liberties. Faith and Freedom comes to you from Liberty Counsel, a civil liberties education and legal defense organization. Join us now as Matt Staver, founder and chairman of Liberty Counsel, explains the latest legal issues all across this country. In the courtrooms of America, Liberty Counsel is winning the battle for your constitutional freedom.
The United States Supreme Court sets a date for oral arguments on DOMA, the Defense of Marriage Act. We're going to talk about that today on Faith and Freedom. I'm Matt Barber, Vice President of Liberty Counsel Action, on the phone with Steve Crampton, Liberty Counsel's General Counsel and Vice President. Steve, thanks for being on again.
Matt, it's my pleasure. It's really it's such an important topic and something I think all of us can really benefit from by focusing on for a few minutes.
Wednesday, March 27th, the United States Supreme Court will hear arguments on both California's Proposition 8 case, which we talked about yesterday, and on the Defense of Marriage Act. This is a 1996 law that was passed with overwhelming bipartisan support and signed into law by President Bill Clinton. Steve, why don't you give us some background on what this DOMA case looks like and what the ramifications are?
Be glad to. DOMA, as you say, was passed with heavy bipartisan support. Many still sitting in the Senate signed on to it. It was unremarkable at the time. Everyone agreed in 1996 that marriage ought to be limited to one man, one woman, and that states ought to have the right to resist the onslaught of the same-sex marriage agenda folks that had started their work back in Hawaii, which kind of led to the passage of DOMA. But here we are now, fast forward, 17 years? And now the tide has really turned, and the politically correct crowd, which grows by leaps and bounds every year, has decided that, of course, it's unconstitutional for federal law to simply set forth a definition of what marriage means for purposes of determining federal benefits, and wants to see this law struck down. So the case that we're talking about here with Windsor involves a same-sex lesbian couple that went to Canada in 2007 and got married, came back to New York, and one of the partners died in early 2009. Well, as of 2009, New York not only did not recognize same-sex marriages, even those that are formalized and finalized from another jurisdiction, but the legislature had several times been presented with bills that would recognize them, and they didn't pass. So you had a real solid history of what we would argue, and have argued in our amicus brief here, constitutes the public policy of the state of New York as of 2009. However, the Second Circuit Court of Appeals, sort of like the Ninth, everybody's now jockeying for position to be the most liberal and creative in conferring rights on homosexuals, determined that, no, we can predict, looking back in time, what New York would have said was their public policy, and they would have recognized this marriage. And the significance of that is that it gives standing to the surviving partner to bring this action and to challenge on the merits the Defense of Marriage Act. So our brief argues really focused on that standing question. If, in fact, New York would not have recognized that coupling as a marriage in 2009 when the one partner died, then Ms. Windsor has no standing to bring this action, and the case just goes away. On the other hand, if the Supreme Court finds that there was standing, what you have in the Windsor case that you don't even have in the Prop 8 case is the Second Circuit Court of Appeals goes farther than most every other court and says it is, under these circumstances, the case that same-sex couples are entitled to intermediate scrutiny. They are a suspect class
Right.
for purposes of deciding whether this law is constitutional, shifts the burden, and basically decimates the fundamental definition of marriage for us all.
Which, of course, courts across the land over and again have said that no, the homosexual lifestyle does not constitute a suspect class. I mean, even the very liberal Ninth Circuit Court of Appeals in the high-tech case said that homosexual behavior, homosexuality, is not immutable, unchangeable, and is not and cannot be considered a suspect minority class. But, that is part and parcel. That's a hallmark of liberal thought and liberalism in practice, is if what your end that you hope to achieve doesn't match reality, why then you just have to assert that reality is not what reality is. And isn't that really what DOMA is all about? People, often say that DOMA was an attack on gays. No, the Defense of Marriage Act is exactly that. It was a defensive act to defend against the radical reconstruction or deconstruction of marriage, something that reality dictates involves a man and a woman. So it's a defensive act, not an offensive act. And you mentioned here, what these judges are doing, trying to create a reality, manufacture it out of thin air, much like the notion of same-sex marriage in general.
That is so true. I really appreciate you putting that forward, because what we're ultimately talking about is the protection of the rights of other states that haven't gone so far as to make up and pretend that homosexuals can marry and be just like opposite-sex couples. It is not by any means an attack on anyone. At the time DOMA passed, every state in the Union had the same definition and understanding of marriage, as has virtually all of recorded history. Moreover, at the end of the day, if they are successful in basically persuading the Supreme Court to engage in further judicial tyranny and force same-sex marriage on the rest of the country, that's what you have, is we're going to fall like dominoes across the rest of the country because of the full faith and credit clause. As soon as they get a marriage recognized in federal law in one state, they'll relocate to all the other states and force it on them as well. So, this is by no means some sort of battle way over there that doesn't involve all of us. This is a battle right here in the heartland of America.
Absolutely. And people need to recognize, too, that this is the notion of same-sex marriage is not some innocuous, just why not let them have it? It's right. That is the head of the spear. That is the sledgehammer that they will use and are already using to crush religious liberty. Christian organizations like Liberty University, churches, private businesses that are owned by Christians, a Bible bookstore. If the law of the land says that this ridiculous and oxymoronic notion of same-sex marriage is indeed the law of the land, then the converse of that is that if you hold the Judeo-Christian view, the biblical view, the hold to the reality that marriage involves a man and a woman, then you are in conflict with the government, with the law, and guess who loses when that happens? Just about a minute or so left.
Matt, that's exactly it. There is no tolerance from the other side. Once they gain their foothold, as we've seen with the likes of the Catholic Charities Organization in Massachusetts, we've seen with Christian wedding photographers in New York and elsewhere, businesses all over the land that refuse to bow the knee to the homosexual agenda, they will eradicate us, and they will not stop until the homosexual totalitarian view of the world is forcefully imposed on every American coast to coast. That's really what this comes down to, isn't it? Absolutely.
Well, folks, those who are willing to take a firm stand for marriage, like Liberty Counsel, are diminishing in numbers because the intimidation tactics are working, but Liberty Counsel is going nowhere. We are here to defend natural marriage as between a man and a woman. To see how you can become part of the Liberty Counsel team, go to lc.org or give us a call at 1-800-671-1776. It's through your gifts and through your generosity that Liberty Counsel is able to stand in the gap and defend the crucial institution of marriage against these assaults. Again, go to lc.org or give us a call 1-800-671-1776. Stand with Liberty Counsel as we stand for natural marriage.
You have been listening to Faith and Freedom with Liberty Counsel. We hope that we have motivated you to stand up for your faith, family, and freedom. We can accomplish a lot when we work together. Get informed and get involved today. Sign up for our free monthly newsletter, The Liberator. We will send it out to you free of charge. Stay informed with our Liberty Alert email updates. Just click on the website at www.lc.org or call us at 1-800-671-1776. Tune in next time to learn more about your rights right here on Faith and Freedom.